Hi, I'm Mike Steger. I'm a copyright and trademark attorney, and I'm going to tell you a little bit about a recent Supreme Court copyright decision. A few weeks ago, in a case called Cox Communications versus Sony Music Entertainment, the Supreme Court greatly restricted potential liability for what's called contributory copyright infringement, ruling that internet service providers, so big platforms that provide general internet service, but probably also a lot of social media platforms, will not be liable in many, many cases when their users post infringing material. In this case, Sony and other large music publishers had sued Cox uh, for enabling rampant piracy and copyright infringement. Cox had a policy that it would not cut off service to uh, users of the service until it had been notified of at least 13 incidents of copyright infringement by each user. The music publishers had won quite a big verdict in the lower courts that had been upheld on appeal, but the Supreme Court said unless the service provider is actively and knowingly and intentionally enabling uh, copyright infringement, it can't be held liable for contributory infringement. This is quite a change in the law for most of the country, but I think for you, the Video Socials viewer, the impact will be quite limited. If your business or your website is actively posting the infringing material, you're still going to be liable. This really applies more to large platforms that act as a host and do not necessarily take steps when the platform is notified that it is hosting infringing material. The entire decision is way too long, way too complicated for a short video like this. But if you have questions about the case, if you have questions about any other copyright or trademark issues, give me a call.